Tonight on Nation to Nation, the Trudeau government looks to remove mandatory minimum penalties on certain drug and gun crimes. Justice Minister David Lametti says it's to fix a failed war on crime by Stephen Harper.
The justice system, in a sense, has tried to rebel against them by finding a number of them unconstitutional, but it's just been a massive failure. Tough on crime was great for politicians and slogans, but it wasn't effective in the courts at all.
These changes are supposed to help Indigenous people, but there's more that could be done, says Indigenous law expert John Borrows, by adding 3 justices with knowledge of Indigenous law to the Supreme Court of Canada.
We need the fuller dialogue, which is again what our laws teach us, is we need various perspectives from different clans, from different parts of society to get to the better decisions.
Hello, I'm Todd Lamoran and welcome to Nation to Nation. Last week, the federal government took its first step in addressing systemic racism in the justice system when it introduced Bill C-22. It aims to do away with some mandatory minimum sentences for drug and gun crimes. The government says these mandatory sentences unfairly affect Black and Indigenous people. It wants judges to have discretion to sentence offenders to house arrest or to seek treatment. To discuss this proposed law is Justice Minister David Lametti. Thank you for joining me, Minister Lametti.
Good afternoon, Todd. Great to be here.
Now, can you give us some examples of the gun and drug crimes you want to ease up on?
Sure, I'll give you examples that are loosely based on actual cases, changing a few facts here or there. But let's say there's this young man up in a remote northern community. He's got a job, he's got a girlfriend. It looks like he's going to finish school. Everything seems to be going well. His family has been subjected to intergenerational trauma, so he's living with all of that. Goes out on a Saturday night with a couple of his friends and has a few beers in a bar, and perhaps has one too many, and takes a dare on from a friend and pulls out his long gun, his hunting rifle, and he shoots a couple of bullets into an empty building. No one gets hurt, except that the neighbors here, they call the police. Police arrest him. He gets charged for reckless discharge with intent, 4-year minimum mandatory penalty. No option for the judge to do anything about that, but give him 4 years, goes to prison, loses the job, loses the girlfriend, never finishes his education. When he gets out, he's lost his friends. He ends up moving in with the people that he was in prison with. What good does that do? Can I give you another one, or I'll give you another one just quickly. You have a young woman, a few kids, again, victim of intergenerational trauma. Has a drug habit that she is funding through selling off her prescription drugs. She gets charged with trafficking. She gets put away with a minimum mandatory penalty. We have to take care of her. We have to take care of her kids. She doesn't get the help she needs for her problematic addiction. Who does that help?
How did we get to this point in the first place where we have mandatory sentences on these offenses?
Well, there have been mandatory minimum penalties on some crimes for a long time, but the Harper government, over a period of 10 years, introduced a number of about 50 minimum mandatory penalties over a period of 10 years that touched on all kinds of offenses, particularly gun and drug offenses. In a so-called tough on crime policy, it's a failure. It has been a failure. It's been demonstrated to be a failure. It's led to the massive overrepresentation of Indigenous and Black people in our criminal justice system. And we're looking to reverse that. The other thing they also did was they took away conditional sentence orders, which took away the ability of a judge to fashion a house arrest where a person would be forced to get help for problematic addiction or be sent to a healing circle, or some other restorative justice program or that kind of thing, which could actually help the person actually promote healing. Minimum mandatories don't do any of that. And sadly, the Harper government just increased the number of them, the frequency of them. And the justice system, in a sense, has tried to rebel against them by finding a number of them unconstitutional. But it's just been a massive failure. Tough on crime was great for politicians and slogans, but it wasn't effective in the courts at all.
Most of these offenses are poverty or trauma-based, as most addictions are. So how do you convince the most hardened, tough on crime people that we need to change as a society or how we look at these crimes?
Well, first of all, the facts don't lie, right? It just hasn't worked. And every jurisdiction in the world, including the most hardened conservative jurisdictions in the south of the United States, are abandoning minimum mandatory. They result in over-incarceration, in particular Black and Indigenous peoples in Canada, but they also cost a lot of money, cost a lot to incarcerate someone when a house arrest with appropriate programming is just a whole lot cheaper. That's part of it. It's partly about being effective on crime. We want to help communities. We want to help victims, and we want to help victims heal. Minimum mandatory penalties don't do any of that. And in fact, the recidivism rates are higher with minimum mandatories than they are going to be if we find some other kind of solution that doesn't incarcerate someone. So we're trying to let the evidence talk. We're trying to let the facts talk. Certainly the issue has been given a greater profile by the Black Lives Matter movement, by the Indigenous Lives Matter movement. But the facts are there. The evidence is there. We need to move away from these things. This is a really, I think, really positive first step that should touch a lot of people and really help a lot of people from both victims and perpetrators to finding a healing solution, a restorative solution, a rehabilitative solution that minimum mandatories don't allow for.
Now, of course, you're keeping mandatory penalties on serious crimes like murder or sexual assault. But there's also, you're keeping them on gang-related violence. Unfortunately, a lot of Indigenous people are caught up in the gang life. So how is this going to reduce that over-representation of Indigenous people that you alluded to earlier?
Well, look, this is a first step, and you're right to say that we didn't touch anything related to gangs or automatic weapons or trafficking, and we still have serious challenges there. And you're absolutely correct, Todd, to say that Indigenous people can and do get caught up in that in an overrepresented fashion, and the same is true for the Black community in certain centres in Canada. Minister Blair brought out a gun control bill this week trying to attack gangs. We've invested money in anti-gang programming and strengthening our borders and anti-trafficking programming. What I would say to you is let's try to make those programs work and keep an eye on the minimum mandatories that still exist there down the road. But for the time being, the priority is on the initiatives that Minister Blair is taking.
Now, before you tabled Bill C-22, there were the Gladu Principles, where any time the liberty of an Indigenous person is at stake, judges must take into account their past and look for sentencing alternatives. But that didn't help the number of Indigenous people, the overrepresentation in federal prison, from going up every year. Why was that?
Well, two major reasons, and I think we've begun to address both. First of all, this package. This package means we can try to fulfill the potential of the Gladu pre-sentencing report. Why? Because we have eliminated a great number of minimum mandatory penalties where a judge can now take into account what's in that Gladu report. And second, fashion a conditional sentence, which will allow for the punishment, if you will, to fit both the crime and the individual and help the community. So there's now a flexibility that we've given back to judges by allowing for conditional sentencing orders and by taking away a minimum mandatory penalty in a situation before where the judge's hands were tied. Second, in the fall economic statement, we've heard the critique that Gladu reports were inconsistent and underfunded. And so we have committed in the fall economic statement to investing almost $50 million in increasing the coverage and increasing the quality of Gladu reports so that they are more widely are more widely available and they're better quality, so that they help both the individual in question to put their story forward and to bring out the real structural challenges that have been caused by colonialism, colonial structures, by residential schools, by other real markers of systemic racism in Canada. By getting those stories out in the Gladu report, we now have funded that better. We're going to continue to fund that better. We're starting a pilot program with respect to the Black community to have pre-sentencing reports as well. So I think we've seen the potential of Gladu reports. We haven't fulfilled the potential of them, but now I think we've taken these 2 steps, and I think we're moving it in the right direction.
Of course, the problem with Gladu reports, and one you'll probably find in Bill C-22, especially when we're talking about a sentence that a judge may give out, one of them may be treatment over doing jail time. But there are so little treatment beds out there. So is there going to be some funding for the social programs to actually help these people?
I think, yes, I think we've committed to that. Again, we committed some money to community justice centers in the fall economic statement. There has been some support for restorative justice programs, and certainly there's a greater interest in drug rehabilitation programs. We're going to push for that. I'm pushing for that additional funding. I know the health minister is pushing for that additional funding. The evidence says we need to move in that direction, and so step by step. But I think we've turned the page on a failed policy. We're pushing it in the right direction, and hopefully we can make those kinds of human investments that will give police officers, judges, prosecutors the ability to divert people out of the criminal justice system into the kinds of programming that they need in order really to better their lives and stay with their kids, stay with their families, stay in their communities, and work, heal with victims and other members of the community.
And finally, I want to just briefly turn to Bill C-15, the UNDRIP bill. You tabled it in early December, but there's been criticism the government has been slow on this one. Why has it taken so long to get a second reading and for it to be sent to committee for study?
I'll be blunt, because the Conservatives are using delaying tactics on bills, particularly the fall economic statement. We've now had more hours of debate on the fall economic statement, the same repetitive arguments from the Conservatives again and again, more than we would have for a full budget. And they're doing that in order to grind the government down, in order to prevent us from getting C-15 and other important pieces of legislation in front of the House. Honestly, we need to call out Aaron O'Toole and we need to call out the Conservative Party because their delay tactics are becoming unbearable. We're losing time on a lot of good pieces of legislation. And as I said, we've already spent more time on this than we would have on a budget, and we're just hearing the same arguments over and over again.
Okay, Minister Lametti, it's been great to talk to you. Thank you once again for joining me.
Thank you, Todd. It's been a pleasure.
After the break, we talked to one of Canada's preeminent scholars on Indigenous law, John Borrows. Welcome back. Indigenous law, it's a term that's often thrown around, but does it have any meaning or relevance in today's legal traditions? Yes, there's agreement that Indigenous law needs to be taken seriously. Yet, how can it when Canadian courts are dominated by English common law? The University of Victoria's law program is trying to do something about that. It offers a joint program in Indigenous and common law. The program is still new and still developing its curriculum. Tonight there will be an open forum of educators giving insight into Indigenous law. It'll be hosted by Dr. John Borrows, a preeminent legal scholar on Indigenous law. Welcome to Nation to Nation, Dr. Borrows.
Great to be here. Thank you.
Now, this is an absolutely unique program, correct?
Yeah, it's the first of its kind in the world, as far as I'm aware.
I've interviewed your colleague, Dr. Val Napoleon, before, and she talked about some of the courses you could possibly take, like Coast Salish tort law. And you think, Coast Salish tort law, but a tort is still just a wrong that brings harm or loss to a person. So, of course, the Coast Salish would have had a way to deal with that. So how do you overcome the perception that Indigenous law has no relevance today?
We help people see law as something that we do. It's a functional term, meaning that it has application in our lives. That is, law doesn't just flow from parliaments and legislatures, courts with the help of judges and lawyers. It's standards, principles, criteria, signposts, guideposts, measures, principles, processes for regulating our affairs and resolving our disputes. And of course, Indigenous peoples have these things. And so the point is to try to bring that to others' attention, what our standards are, what our principles are, what our criteria, measures, signposts are, so that people can see that in the contemporary setting, we can regulate our affairs and we can resolve our disputes.
How difficult do you think it'll be to reconcile what appears to be two different legal traditions, Indigenous versus common law?
Yeah, well, there are things we don't have to reconcile. They can stand on their own and be exercised and practiced without always putting them together. But there are other places where they can be put together. The Supreme Court of Canada has talked about this area of law being intersocietal, and saying that a morally and politically defensible conception of our rights will incorporate both Indigenous legal perspectives alongside the common law perspectives. And of course, within Indigenous legal communities too, we also have frameworks that help us to think about how we absorb or take account of or distinguish other points of view and other ways of life. And so both within Canadian law and within Indigenous legal traditions, there's ways of thinking about holding things apart and also putting things together.
How do you foresee this forum you're mediating tonight helping to develop curriculum for the program?
Well, it's about talking together and sharing with one another the ideas that are out there to ensure that we're supporting one another, causing this resurgence of Indigenous law to be something, again, that people do, not just that is done to them. And so while we talk with others, invite their participation, we learn from them, and hopefully we can share something in return. It really is about building the opportunities for practicing with one another what our laws can be.
Now, I've heard it suggested, and again, I think it's from your colleague, Dr. Napoleon, that if Indigenous law is taken into account more seriously, a lot of these disputes we seem to have between Indigenous and non-Indigenous societies may be smoothed over. Is that something your view as well?
I mean, conflict will never go away, but we can have ways of disagreeing with one another more agreeably. And so if we take things like environmental assessment, if Indigenous peoples bring their own laws and their own processes to that, we are more likely to get to solutions because we're hearing from different points of view. Likewise, in the criminal justice system, if Indigenous people's laws and views are more fully taken into account, then there's less chance for that disagreement. Likewise, in the child welfare system, there's this Bill C-92. Indigenous peoples are enacting their own laws according to their own self-governance to take responsibility for their families. And again, if Indigenous law is doing that, that's going to help us solve these problems. Rather than someone else telling us what to do, we are developing and generating our own answers to our questions, and then correlating that, coordinating that with other jurisdictions, other peoples.
You just mentioned Bill C-92, where, of course, Indigenous law is going to be used to take control of child and family welfare. How ready, or are we at that point where, I guess, Indigenous groups all across Canada can do that?
Yeah, so I've been talking with Indigenous groups across Canada, and they are developing these laws. And in some ways, these laws are written, and they're going to be in pieces of legislation that communities might pass. But in other ways, these laws are long time part of our communities, and just bringing them to the surface. So some of the discussions I've been having around this area are people are talking about introducing naming more strongly into the community, understanding what the clan responsibilities might be, with the umbilical cord, burying that in the ground and performing ceremonies around that, giving mothers the support that they need in relationship to their children. That is, law can be written down in this area, but law is also something that we do, and it's something that is not just done by government or lawyers or Indigenous leaders. It's also done by elders and grandmothers and grandfathers and mothers and children themselves, are legal practitioners in our way of thinking about the law. And so this is part of the revitalization process, is to see law become more diffuse, more participatory, and to take off some of those shackles that are there that didn't recognize the kind of the broader societal engagement as a part of our legal traditions.
How long do you think it will take to train lawyers who may then become judges themselves, so that their influence, that the influence of Indigenous law is felt throughout Canada's legal tradition?
Yeah, so this is a process that never ends. Law is always in development, but in order to get people that would be ready to, say, become judges, it's a 4-year process to go through the law degree. Then you get articles, which is an apprenticing opportunity, and then you work for about 10 years before you're eligible to sit on the bench, which is why it's important not to see judges and parliaments and legislatures as the pinnacle of what we're talking about. It's really empowering people in their daily walks of life to understand that they have a piece of the law and they can pick up their responsibilities under that piece of law, because we can wait a long time for those other folks and they are going to come along. But in the meantime, there's so much that we can do to be a part of this.
I just want to change topics a little bit here. Your name, of course, was floated as a possible candidate the last time a seat opened on the Supreme Court of Canada. Did you feel you were headed to Ottawa?
No, I think that this is something for other people to do. I'm really loving being a teacher and trying to work with communities and bring these ideas to light. And my hope and my role is to be an encourager of other people to help them achieve all the aspirations that they have.
Now, it may be decades from now, but should the Supreme Court of Canada have a seat for somebody with knowledge of Indigenous law, the same way 3 seats are reserved for Quebec's legal tradition?
Yeah, I think there should be 3 seats that are on the Supreme Court. That is, we would have the 9 that are already there. We would add 3 more, which would have different Indigenous legal traditions as a part of the way they think through making judgments and relating to the cases and the possibilities. It's never enough just to have one voice in a place. That can be a bit narrow. We need the fuller dialogue, which is, again, what our laws teach us, is we need various perspectives from different clans, from different parts of society to get to the better decisions, because we really do benefit from having many different perspectives that come to particular issues.
Now, it might be a bit controversial, but should we get rid of the French requirements so that more Indigenous lawyers and judges can sit on the Supreme Court of Canada bench?
No, I don't think so. I think we can keep that requirement and add to it and see that there's an opportunity for a much broader engagement rather than narrowing and shutting people out or down. Obviously, the civil law is an important part of our country, and the French language is a part of who we are, but we can add to that. And the point is to see that we're not just a bi-juridical country with the civil law and the common law, but we're a multi-juridical country with the civil law, the common law, and Indigenous legal traditions, and that needs to be a part of the broader mix.
Well, let's hope that broader mix happens someday soon. Dr. Borrows, thank you for speaking to me.
Okay, take care.
We'll have more after another short break. That's our show for this week. In the interview I just had with Dr. John Borrows, I mentioned his colleague Val Napoleon a couple of times. So if you want to hear from her more about the Indigenous Law program at the University of Victoria, go to your podcast app on your phone and check out the Nation to Nation podcast from February 22nd, 2018. It was a very interesting interview. Anyways, I'm Todd Lamoran, hoping you're keeping safe and healthy. Thanks for watching.